Well, good morning. This is Kristen Ishihara and Chris Parker. We're with Ishihara and Parker Law Firm here in Longview, Texas, and we are excited to welcome you to the very first edition of Estate Planning Texas. So welcome.
Yeah, excited to have you guys here. We are trying this out for the first time in our new format, so we will work our way through as we go. What are we covering today?
So today, Chris, we just have talked in the past about that there are just not a lot of resources online for people when they go to search and say, what do I need to have in place for my estate plan? I'm looking to retire next year. What are the documents I need? How can I make sure everything's set up for my mom and dad? So we just wanted to provide some pretty basic information that would live online, that would allow you to, without any, obligation, just figure out what it is you might need to have in place. So we thought today we just kind of run through, all right, you're sitting at home and you're ready. You're ready to get it done, and you call our office or a different attorney's office to get that done. What are they going to ask you? What do you need to be prepared with? What is the first consultation going to look like? So just kind of, from the basics. It's like a couch to 5K plan. So you're just sitting at home, you're ready to do it. Okay, here's what we might need. So let's say I'm sitting at home, I call up our office. What happens?
Yeah, so you give us a phone call. You're going to speak to the office staff, the secretary. They're going to work on scheduling a date and time that works for you. They'll put it on the calendar. And when you show up, you're probably thinking, hey, what do I need? What kind of preparation do I need to have? I don't think it's that intense. For most folks, what we're talking about is very simple. Your full name, right? Your date of birth, your address, things that we're going to find on your driver's license, the name of your children, the addresses, people who are important to you. If you have reliable adults, children, whoever it may be, who may have roles in your life as you get older, we want to know their full names, their addresses, their phone numbers. But we're not asking for, we don't need complicated tax forms. We're not needing a lot of deed records. At the very beginning, we just need to know who you are accurately and the details that go with it. So don't let the build-up be a delay factor. We see lots of procrastinators.
Absolutely. We don't want you to be scared. You could walk straight in off the street and the information you have in your head is more than likely enough. Or in your phone.
Oh, gosh. Every
it's perfectly
time
fine to check your phone.
That cell
That's
phone,
right.
and it's amazing what we carry on there, and that makes our meetings so much more efficient.
Absolutely. But we do have, in our office, we have an estate planning checklist that if you make an appointment with us, we will send you ahead of time. The stuff that's listed on there is just, we're going to ask you if you have other professionals in your life, like a financial advisor or CPA. We usually want to coordinate with them and make sure we're all on the same page. But then, like Chris mentioned, just everybody's full legal names, address, who you would trust to be an agent. You don't have to ask them to serve as your agent prior to meeting with us, but that's something we usually would encourage you to do. If you're listing someone as an agent, ideally you want to make sure they know that they're being listed, that they're okay with being listed. And sometimes you do want to check and make sure that you remember how you spelled your kid's middle name. You don't have to know that, but getting that information correct is important, so we don't have to update that later. So if you forgot whether you spelled it with an H or not with an H, maybe check the birth certificate, but not important to have on the first consultation, certainly. So we've gotten set up with that consultation. We've come in, just some basics that I want to make sure people know. There's nothing scary about being in a lawyer's office. Sometimes people are intimidated. They've never met with a lawyer. Fortunately, you've never had reason to need a lawyer before, right? We're not scary lawyers. We often wear jeans. We do not have any expectation of you being prepared or dressed up or professional in any way. If you wear a hoodie and sweatpants or roll out of bed in your pajamas, we're perfectly happy to see you. So there is no expectation really of presenting in any sort of way. It's just, we need to help you get your stuff in place. But okay, so I've made the appointment. I show up. What happens next?
Yeah, so you come on in the front door. You'll be greeted by staff. They'll throw water at you, make sure you're comfortable. Have you fill out one of our sign-in sheets to make sure we have those basic information, who you are, where you're from, a phone number. Eventually, we'll move you back to one of the conference rooms. You and I will hustle in there pretty quick. And we'll sit down and start talking to you. And most of the conversation starts off as, hey, I'm Chris, you are Mary, or whoever. It's nice to meet you. And as we go through that conversation, it's starting off with truly the basics of what you need to have done. Now, if you don't have some of these things done, it might be worth paying attention to. But I ask basically the same time, are we here for you or for someone else? Regardless of who we're here for. Have we or do we know what powers of attorney are? I mean, that's where I start with everything, Kristen.
Absolutely.
How about you?
Yeah, same. My initial conversation with someone just starts at okay, Everybody over 18 needs to have these in place. So it's not, have I reached the age where I need it? Is it time for me to do these things? It's just everybody should have them. So if you're an adult, these are the things that you should have. So it's relatively simple. It's not, making a case-by-case decision in that scenario. There are just some things that everybody needs to have.
So everyone over the age of 18 in the state of Texas should have their powers of attorneys completed.
Right.
It's not even a question of when or how. If you're over age 18, you need your power of attorney. But my question to you is why?
So if we needed to have those in place, that would be because we need to take the opportunity we have now to put in place a trusted agent. So, for example, my financial power of attorney lists my spouse first. Okay. If I were incapacitated, he could pick up the phone and talk to my life insurance. He could talk to my retirement plan advisor. He could handle any business that I would need to have handled if I were physically unable to do it.
But if you're already married, couldn't your spouse already do that?
That's incorrect. So that's something that people often misunderstand. If we jointly own our bank account, my husband can control that because he's an owner. But there are some things that will only have my name on them. Some things that are silly, like a utility bill or cable bill, may only be in my name. Well, just because he's my spouse does not mean that he can handle them. He has to be appointed in writing with that financial power of attorney to do it. Right now, it's just for convenience, right? If I'm not available, he can call and handle it. But if I'm incapacitated, it becomes suddenly much more critical that he have those documents so that he can handle what he needs to handle. If I don't have those in place, what happens is a adversarial guardianship proceeding that costs thousands of dollars, where the court says, this is who can make decisions for you because you're not able to do it. But right, in Texas, that is so very important that you have a financial power of attorney in place. I couldn't stress that enough.
So in other words, just because you're married does not mean your spouse has the ability to take care of and manage your financial affairs if you're impaired. And that is one of the biggest mistakes, misunderstandings we see, which is why we want to get these documents done. When we're doing our financial powers of attorney, so we name our spouse. Do we name backups?
Absolutely. And you don't have to name your spouse. My spouse is trustworthy, so I've named him. But you can list anybody that you trust to do it. Doesn't have to be a family member. Doesn't have to be a spouse or a child. It can be a neighbor. It can be a Sunday school friend. The most important thing is that you are listing a trusted agent and that you are listing more than one. So if you have a primary, you list a backup. If you have two primaries, that's fine. But you want to have at least two people on there. You can list as many as you want, but you need to have at least two.
And the reason for that is because we have seen agents or powers of attorney that are older, and the documents are older, and the agents have passed away or been unable to serve. And so we have to go to that next level of agency to serve or protect our individual, our client.
Absolutely. So while we recommend that you pull your estate planning documents out every year and review them, it is not uncommon for you to put them in place and never think about them again. So 30 years later, we want to make sure that you have some backups listed. So if that is what you decide to do, that you've put in place something that can stand the test of time, that can still be used at the time that you need it.
So I want to fast forward just to the end on this one. So I met with you. I realized the importance of powers of attorney. I've named multiple agents. I've given them phone numbers. I give them addresses. And then I signed the documents. Once I sign those documents, am I done? What happens? How do I keep or store? What do I get?
Yeah, so any documents you do with our office, you retain the original documents. You need a safe spot for that, somewhere that you feel good that your loved ones could find. You get a paper copy and a thumb drive. If you are comfortable, you would want to share a copy with those agents so that they have it. You would also want them to know where you keep the originals and have access to it. And then best case scenario, let's say that I am a surviving widow and I have adult children now. I would really want you to take those adult children with you to meet with your financial advisor, to meet with your banker, to meet with your lawyer, even maybe start taking them to some doctor's visits at some point in time. But then as you're doing that, you're providing the financial advisor that financial power of attorney. They're meeting your child, they're recording it, so now they know if something happens in the future, this is the person I need to get in contact with.
Yeah, what a great point. So we have seen it where, things go wrong. They do. Mentally, physically, things can go wrong in your life. And your trusted agents, your medical professionals, your financial advisors, they have duties and responsibilities that they have to uphold to you. And when they don't know who your son is or who your neighbor is or who that good actor is, it can cause them a lot of concern. We see senior scams all the time. And that's the exact concern your professionals in your life are going to have.
Absolutely.
If they know and have met your son or met your neighbor, have met your trusted friend and know them for 10, 15 years, then that period of, that danger, that period of whatever's going on in your life is much easier to transition. But you have to give the tools to those professionals who need it. Another thing I always recommend too is I get all these documents done. I think you should share them because you want to start setting expectations. I've seen many families who have a lot of things going on, but because mom and dad have told them this is what will happen, there are no disagreements. There are no confusion. They have managed expectations. They've done it for 20 years, and everyone knows the game plan.
Yeah, absolutely. Best case scenario is everybody is involved and everybody knows what's going to happen. There are no surprises at end of life or after you've passed away. The financial advisor, some of our bigger institutions may have their own form for that. I think they often call it a trusted contact. And so that's a great thing to have in place because it allows them, if you call and say, I want to withdraw all my money and send it to someone in the Bahamas, they can call that trusted agent and say, hey, mom or dad is making some strange financial decisions that seem out of the ordinary for them, and kind of alert you to a situation before it's too late. Anything that you can do to build that network will just be so valuable.
And I hate to say it, don't think that won't happen to you. We get calls, somewhat routinely about, someone being taken advantage of, someone wiring funds, someone go to the bank and transfer Social Security checks. And it's very difficult for anyone to fix that problem outside of government intervention of a guardianship, and even that's a far from perfect solution.
After the money is gone, it's gone. There's really, just practically speaking, it's not going to be recovered once it's been gone. Once it's lost. So anyway, where we started was financial powers of attorney. Very, very, very important to safeguard yourself and your family.
All right, so we've talked to you. You convinced us. We're going to get our financial power of attorneys done. There's a short form, long form. We'll talk about that when we meet in person, but or detail later. But I wonder what's next after we cover the finances.
Yes, financial power of attorney. Next is a medical or healthcare power of attorney. So same concept. We want to put in place someone we trust to make medical decisions for us. This is a great opportunity to talk to your family about that. Maybe you have one child that would pull the plug, no questions asked. Maybe you have one child that would never pull the plug. Knowing, what their emotional ability to handle those decisions is important. And making sure that you fully communicate what your wishes are.
Well, let me make sure I understand this, because this is Texas and I want to be in charge. Why would I want to sign a medical power of attorney? Wouldn't I be giving up control?
Oh yeah, super question. So any power of attorney, you remain in charge. You are still the boss. You still make all medical decisions and financial decisions, but you're saying in the event that I'm unable to do so, I'm giving this person authority. So your medical power of attorney does not come into place unless you are unable to answer because you are unconscious or incapacitated, and only then can my medical agent make a decision for me.
Give you a silly example. I am a long-term smoker. I have been smoking all my life, and I'm now 80 years old, and I would like to continue to smoke. My doctor and my adult daughter have a different opinion, right? They are telling me that I need to stop immediately, and I'm not able to smoke anymore. My opinion is I would like to continue.
Sure.
Who's going to win that arrest?
You're in charge of yourself. Smoke away.
Smoke away.
Smoke away.
There you go. Pro smoking today.
No.
All right. Perfect. Okay. So we covered the medical power of attorney. We've named trusted folks to help us out when we can't make those decisions for medical. What's next?
Next one is we would recommend you have a generic HIPAA authorization. It allows healthcare information to be shared with all those people we've listed as agents. Sometimes you might list even more on there. So if I've listed my spouse and then one kid as my medical agents, maybe I go ahead and list all my kids because I don't mind if they talk to doctors. If something's happened that they share the information, that's fine. But just a generic one that would say these people can get information from my healthcare providers.
So the way it works practically is I can have multiple people listed on a HIPAA release, which means those folks can know what's going on with my medical history. But when it comes to decision time, that still relies upon the medical power of attorney.
Right. Yes.
Okay.
Yeah, those can be different decisions.
Yeah. So more people can know, but ultimately the decision making goes to the person or persons listed as medical power of attorney.
Absolutely.
And I guess I should say that you don't have to have one agent at a time. You can have co-agents if that was appropriate for your situation.
You sure can.
Okay.
Yes.
So financial, medical, a HIPAA. I do want to talk end of life. What about advanced directives?
Sure. So, when you go to a hospital, they always ask you, do you have a living will? We recommend that you, as long as it is what you want to happen, that you have a directive to physicians, which is also called a living will, in place. That is the one that says if I'm in a permanent vegetative state, that I not be kept artificially alive that way. Now, if you have a medical power of attorney, that person can make that decision for you. So I would say the goal of that document is really to help them know that's what your wishes are.
And this one's can be touchy. I've seen plenty of folks who are unable to really process or discuss end of life decisions, and so like they'll shuffle off every other decision, not come and get it done because they don't want to talk about death.
Sure.
That's okay. Medical power of attorney can handle it, but I do like to cover a scenario where this can be important. Blended family situation. Just hypothetically, I have an older gentleman, a younger wife. They've been married for 30 years, but he had kids from before marriage. He suddenly has had a medical event, and he's never going to return.
Yeah.
Wife knows his wishes, and so the hospital's asking her, hey, you're the medical power of attorney. It's time to make the decision to let your husband go. His adult children show up. They're furious. Why are you killing dad? I mean, that is a scenario we see play out over and over, which is sometimes when I say medical power of attorney, HIPAA release, advance directives are important, but in a blended family situation, they can be a real godsend for the surviving spouse.
Absolutely. And even more so to your point that it's great to communicate that ahead of time. So if you do have that blended family situation, everyone should know who the appointed medical agent is and ideally why you've chosen them. This is what I want. This is what I know they will do. And sometimes it's uncomfortable, but having those conversations can just be such an emotional gift to your family at the time that you've not created additional angst when, it's already a very hard time.
Let the mourning be over your condition and your
Right.
loss, not over the paperwork and the battle amongst family members over control.
Yeah, absolutely. So you walk into our office, we're having this conversation with you as a potential client, and we're saying you need these 4 documents: a financial power of attorney, a medical power of attorney, a generic HIPAA authorization, and a directive to physicians. Everybody over 18 should have them. Period. End of story. So it doesn't matter who you are. If you come into our office, you will have that conversation.
We'll try to slap down on everyone we see because
That's very important.
The results
Absolutely.
are guardianship,
Absolutely.
and you would like to avoid that at all costs.
Yes, we would like to avoid that at all costs.
Yeah.
Yes, those are unpleasant. So in addition to that, the next step, so everybody should have this, those 4 documents apply while you are alive and they go away when you pass away. Your authority to that agent ends immediately upon your death. So a financial power of attorney can no longer handle your bank account or handle your car title or handle anything after you've passed away because those immediately end. So the next thing to consider is what happens at my death. How do I put somebody in charge? How do I transition assets? And we have a couple of options that we usually talk to clients about, but let's just stick with the basics today. That's the title of our whatever this is. So we'll stick with everybody should have a last will and testament that expresses what your wishes are when you pass away. It was kind of shocking to me that only 46% of Americans have a will in place. And I'm curious, why do you suppose that is? Why would somebody not have their will in place, do you think?
Based on conversations with folks, they all say the same thing. They don't want to talk about death. They're avoiding the issue. I guess they think by not talking about it, it won't happen. And of course, that is the biggest mistake. It happens to us all. It is guaranteed you need to write a will. People don't want to talk about it. And the other thing that surprises me is I see people come with these wills and their loved one passed away years ago. And they say, well, I own this and I own this because, mom or dad or loved one left a will. And I say, okay, great. And I said, did you probate this will? And of course, they look at me so confused and said, probate? Well, they wrote the will. Why am I asking if the will's probated? What does that mean?
Sure. Well, so let's start with valid will in Texas. Can be done in 2 ways. One is holographic, all in your handwriting, signed and dated by you.
Don't do that.
Yeah, not ideal because you're going to mess it up. 2 is usually you've done it in a lawyer's office and it is witnessed by 2 people. It can be self-proved then by having a notary. But so many times people will say, well, I have a will in place. I wrote down something before I got on a plane to go on vacation with my entire family. So that's my wishes. Well, they are not your wishes that can be validly carried out if they're not done correctly. So you have to take the opportunity to do a valid will. When does that will actually transition property to anybody? You have to die, and that will has to be probated within 4 years of your death.
In other words, that's the follow-up.
Right.
Well, let me ask you this. So let's just say, okay, I know I need to do a will, but either I didn't write the will correctly, or I knew I was supposed to do a will and I procrastinated and I managed to get myself, deceased. What happens?
So if you pass without a will, Texas writes a will for you. It may not be the will that you would have chosen, so it is so important that you take the opportunity to say who gets your property at your death and do it in a legally valid way. It is worth, I think, that people sometimes don't do this because, one, they don't want to see a lawyer and they don't want to pay a lawyer.
Yep.
And I promise you the cost of doing your will correctly is worth saving all of your assets and making sure that they go to the right person, because that's what you're risking. Everything you worked for during lifetime being... now, the state doesn't take it. A lot of people will think that the state steps in and takes it, and that's not true. But Texas will say who it goes to. And so there's some scenarios that people are not expecting. So let's use some examples here. Do you have one you want to share?
I mean, I'm just thinking blended families right off the bat. I may have been married to my spouse for 20 years, but if my wife purchased the house 1 year before marriage, that would be her separate, that would be my spouse's separate property. If she has children before marriage and then she dies, I have a real problem.
I'm living in her kid's house.
Yes, and we see that play out all the time. When my spouse dies, her adult children, it's going to get messy. Do I own it 100%? Absolutely not. Am I putting improvements, upgrades in this? Who's paying property taxes, insurance? Am I abandoning it? Suddenly I went from losing a spouse to potentially in a situation where I'm going to lose my home.
Right.
And that's an unintended consequence many times. I've seen people who've been married for years and years and years and are suddenly looking for, children went back when my spouse was 18.
Yeah.
A different life, a different
Children
world
you
ago.
have never had a relationship with.
And that is a very tough conversation to have. I usually pull out a chart and say, if I'm pulling out the chart to look at intestate succession, we're going to have a problem.
Right.
Well, let's talk about whose car that actually is or who owns half of it. Let's talk about inherited property that your spouse got that's not going to go to you. I mean, it can get hard conversations.
I would say the two that we see the most are, you are a blended family. So one of you has kids from outside the marriage, and you have been married 60 years. But somebody has a child outside the marriage. Everything you acquired was during the marriage. So your home was bought during the marriage. It's community property. Well, if your spouse passes without a will and there's a child outside of your marriage, that half of the house does not come to you in Texas. That is so critical to know and to understand. And you have to have a will validly done that leaves you the house, and that will has to be probated within 4 years. The time that this comes up is when you are trying to move on and you are trying to sell that house and downsize or move closer to your kids, and suddenly you're told by the title company that you only own 50% of the house, and you have to track down your deceased spouse's kids that you may or may not have had a relationship with.
Or their kids.
It is awful.
Yep.
So please understand, if you have a blended family or separate property, which could be all children are of your marriage, but that house was acquired before marriage or inherited or gifted to your spouse, that separate property will not come to you under Texas law unless your spouse has a valid will and that will is probated within 4 years of death. I couldn't emphasize that more.
Yeah, I mean, sometimes people come in and say, well, I wasn't real clear whether I should probate or not, and I'm usually the opinion of, does the will leave you everything? Yes. Well, then your answer is clear. Why would you not probate? I mean, oftentimes people ask me, what's the benefit to probate? And sometimes I do struggle with that in a traditional family where the kids are of the marriage and there's not a lot of things going on.
Sure, sometimes you don't have to probate.
But having said that, it's always a thought process. And the go-to answer I give is, listen, in my opinion, you should very strongly consider probating. I don't know what the troubles may be in the future, but I know this will fixes them.
Yeah, absolutely. Absolutely. What are some other things that we could address? So we're just, back in our client consultation, what are some other things that we need to think about putting our will in place?
So people come in, of course, they've got a spouse, they've got children, but another reason I see people procrastinate, put it off, don't want to handle it, is they say, well, I have Fluffy the dog, and I love the dog, and both my kids want Fluffy, and or some item or something. They won't make a decision because they're afraid that if they make a decision, that they pick someone when it comes to individual items, my gun, my classic car, that they will alienate family members. My biggest one I've seen is people afraid to make decisions because they can't decide personal property items of high emotional worth.
Yeah.
And I always tell them, by not deciding, you've made a decision. That is the decision. And so don't let that stop you. There's ways to do it that are more informal. There's ways at which are more family oriented. It doesn't necessarily have to be in the will itself. We can do memorandums. But please, oh please, don't sit on something just because it's a difficult decision or because you love two kids equally.
Right.
That would be a reason to definitely get your stuff done, not get it done.
Yeah, absolutely. Some other things to think through are, do you want to make any specific bequests? They could be tangible personal property items, a family ring, sentimental gun. It could be things like your house. Maybe you want to leave that to a specific child, or you want to leave your specific family farm to one child, or whatever it is. Specific bequests you need to think about, because those would otherwise not go that way. Any charitable bequests you want to make. So if you want to leave your church either a certain amount or a percentage, those are things that need to be included in your estate plan. And then at the end of the day, so if you are trying to do a will by yourself, one of the things we often see people forget is that you just need a residuary that adds up to 100%. So a lot of times people doing wills on their own will say, I leave my house to these people, I leave my car to these people, and then nothing.
Period.
Right. So there's other things at your death that you're not thinking about. There may be, if you were in a car wreck, you may have an insurance check coming from your totaled car. If you have refunds from supplemental insurance, it's probably only a couple $100, but there are some things that you are just not going to think about that need to be accounted for at the end of the day. Maybe we've had an estate sale with all of your personal property and there's funds left and what we would just call the residuary. At the end of the day, something needs to add up to 100%, and you are saying these people get whatever is in my estate broken down in these percentages. Maybe it's kids in equal shares, maybe it's your favorite grandkid. We don't care who it is, but you need to have specific bequests, if you want any, and then a residuary that adds up to 100% saying who gets whatever I own at time of death. And that goes back to, I put it in place 30 years ago, I've never thought about it again. Again, not recommended, but then whatever you own at time of death is included in that will. We're not trying to say, I'm going to own this house, I'm going to own this car. And that sometimes I think causes people to delay putting things in place. Well, I'm going to downsize from this house and we're going to move. Doesn't matter. Your will is just going to say, whatever I own at time of death is probably sold and then transitioned in these percentages to these people. So it doesn't matter that you will change assets between the time that you've put your will in place and the time that you pass. Of course, that's going to happen.
So everyone needs a will. Those who are in blended families with children before marriage really need to have a will done.
Absolutely.
So we know what's going on. What about people with disabled children?
Yeah, so that's going to be a whole other show probably, but if you have disabled children, you need to pre-plan for that, because if you allow Texas to write that will, they're going to leave that child a share, and that child's share needs to be held in something special called a special needs trust for their benefit. You cannot list that disabled child as a direct beneficiary, and you need to have a will or a trust set up during your lifetime that's going to manage those assets for that child. Otherwise, they're going to be denied Social Security, they're going to be denied Medicaid. So you've really, by leaving them money, you've actually put them in a worse financial situation because they've lost all the benefits that they've had during your lifetime. So planning is crucial there.
Right? You convinced me. I've done my powers of attorney, financial, medical, HIPAA, advanced directive. I've got my will done. You give me this real nice binder. I've got everything in there. It has all my documents, maybe hers, all the way through. I got copies on the left, front. I got copies on the right, back. I've got my originals in the middle. I got my thumb drive. What do I do? Stick it behind the door. I'm done.
Well, you want to review it annually. So, you do your taxes every year, hopefully. So I usually suggest that's a good time to just think about all your business. So you have it in a place where you can review it every year and confirm, are my agents still my trusted agents? Maybe your kids have grown up and now they're appropriate to list as backups. Maybe they have gone the opposite direction and they need to be taken off. Right. Are my beneficiaries still who I would want to receive stuff? And then as a comprehensive part of your plan, both when you put it in place and then ongoing, you need to confirm that you understand how all of your assets will transition. And we'll do some additional shows about this specifically, but my will is only going to transition estate assets that pass through my estate, which is usually my house and personal property and cars. If my bank account has a different beneficiary, who does that go to?
Person listed.
Right. So if that person is different than who you want to get stuff in your will, those all need to match. So annually, look at your estate plan and make sure it's correct, but then also you need to review your beneficiaries on your life insurance, on your retirement, on your investment, on your bank account. Anywhere that you can have a beneficiary, it should be reviewed to make sure that it is set up the way you want it, and hopefully that matches the will. But, you know, make a conscious decision about who are your beneficiaries.
I've had several people over the years say, I'm doing this with my will, but this bank account is going to a different person, and I don't want that in my will.
That's fine.
Which is fine. All we care is that you do it with knowledge.
Right.
Intelligently get it done. Okay, so I got all those done. I've got my copies. I got my original. It doesn't matter which one I keep, right?
You need the original.
Need the original.
Sorry, trick question. I wasn't paying
yeah.
attention. No, and you need the original.
Yes, we're going, y'all. In the law, under probate, the original will matters. And in that case, it is the responsibility of you to find a way to store it, keep it, and make sure it's shared with the folks who need it. The executor, the adult children, the surviving spouse. You know, high, dry, not burned up, not lost. Those are all important things.
Right. And just to round out our, you know, if you were a client that came into our office, we talk about having your powers of attorney and directive in place. And then will is a bare minimum. Everybody over 18 should have it. Then figure out how it interplays with all the assets that you own. We do then talk about the other options, and we're not going to do that today, but probably in future shows, we would talk about some more sophisticated plans, like a revocable living family trust, maybe an asset protection trust, maybe you have a taxable estate and need some additional planning. All of those things are part of that consultation, just depending upon you and what you need. But the basics are financial power of attorney, medical power of attorney, HIPAA, directive, and your will. Every single 18-year-old should have these in place. That means you, that means your parent, that means your child, that means everybody. So we just wanted to make sure that we very clearly communicated these things are super important. They should be put in place for everybody, and there's really no reason not to get them done.
Yeah. And of course, thank everyone for joining us on our first ever.
I know, very exciting.
What do we call it? YouTube podcast?
We are Facebook Living this, and then we'll upload this to our Estate Planning Texas YouTube channel. So we'll be making more content in the future. If you have any topics you'd like us to address, feel free to drop those in the comments, and we'll do our best. But we just wanted to make some content available that people could review and hopefully ease their minds about getting those things in place. Because it doesn't have to be hard.
No.
I can't tell you how many clients leave the office and think, oh, that was way easier than I thought it was going to be. Yes. We are trying to make it as painless as possible. We want you to have everything done that you need.
And where will they find us?
Oh, if you were going to find us, you could find us. Our website is in the link there below. We're located in Longview, Texas at 3000 HG Mosley, and our phone number is 430-625-3110. You're welcome to reach out to us on the website or give us a call at the office.
Thank you.
Yeah, thanks for being here.